This time we'll call to order the regular meeting of Common Council for February 18th, 2026. Carrie, roll please.
Alderperson Carpenter.
Here.
Essercon.
Here.
Gantz. Here. Hanson.
Here.
Kuniger. Here. Ledvina.
Here.
Nelson.
Here.
P-Rock.
Here.
Mayor Boyd.
I am here, thank you. Item 3, Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Item 4, approval of the minutes.
Make a motion to approve.
Second.
Motion by Alderperson Carpenter, seconded by Alderperson Ledvina. Discussion, comments? Looks like we're all good. That said, all those in favor say aye.
Aye.
Opposed? Motion carries. Thank you. Still on the agenda is presentation and awards, the presentation by Brown County on the Southern Bridge. That, however, is being pushed back to a future meeting, so we will not have the presentation. So saves a little bit of time here, huh, folks? So we will keep you informed as to when that will come forward. Item 6, public comment. Does anyone have any public comment on items that are not on the agenda? If so, just state your name, either in person or virtually. So, in person, I assume everyone's here for items on the agenda, but if anyone's here for items not on the agenda and you want to speak, now is your time. That's the second notice. For the third and final time, anyone who wants to speak while the public comment period is open, now is your time to speak. All right, let's move on to new business. New business, item 7A, nuisance abatement appeal by Rachael Carriveau. We are now on item 7, nuisance abatement appeal by Rachael Carriveau. I will now turn it over to Attorney Bungert to review the procedure for this item. Attorney Bungert.
Yes. Just grabbing my little notes. So before I review our procedure and process for the hearing, I just wanted to briefly summarize the context of the appeal, as I believe it's the first time a chronic nuisance appeal has been held in front of the council. So pursuant to our municipal code, section 78-8, any premise that has generated 3 or more calls for police services for nuisance activities, as defined under the ordinance, and has received more than the level of general and adequate police service and has placed an undue and inappropriate burden on the taxpayers of the city, it's considered a chronic nuisance premise. Pursuant to that same section, council authorized the chief of police or their designee to charge the owners of such premises the costs associated with abating the violations. In further, when the chief determines that 3 or more nuisance activities as defined resulting in enforcement action have occurred at the same location within the last 12 months, the chief can issue a notice of chronic nuisance. And accordingly, the appellant is seeking to appeal that determination specifically that was made by the chief with respect to this property, determining that it is a chronic nuisance property, that there were at minimum 3 qualifying calls that rose to the level of a nuisance activity. And so the task in front of council this evening is to listen to the testimony and evidence presented and either uphold the chief's determination and deny the appeal, or reverse the determination and approve the appeal. So now on to process, just the housekeeping matters that have to get taken care of. So this will be a quasi-judicial hearing to ensure that we have a fair hearing in both form and substance. Both parties will be able to present evidence and testimony under oath. All those testifying that are excluding attorneys representing the city and the appellant will be sworn in by the clerk. The council will be able to ask questions of the parties throughout the process prior to deliberation. After that portion is concluded, council will move into closed session to deliberate and then move back into open session to announce their decision. A couple items that we do want to note for the record. First, the appellant, Rachael Carriveau, was given notice of tonight's meeting and is present this evening. Just want to confirm that she is present. She is. Okay, perfect. As is Assistant City Attorney Eric Erdman, who will be representing the city. Second, I would like to confirm that there are no conflicts of interests for any of the alders. No one has prejudged the matter, nor has received any communication from any of the parties.
All good?
So no disclosures, we
All
can
good.
move on. Yep. In the record, we have the nuisance abatement plan, the appellant's appeal request, the nuisance abatement report, and each of the parties will have 10 minutes to present their testimony as well as any additional evidence that we can enter into the record. The city will proceed first, followed by the appellant, and then each party will have an additional 5 minutes for rebuttals or closing comments. Once testimony is concluded and all the questions have been answered, asked and answered, I should say, we can move into closed session by roll call vote, and then come back into open session to issue the decision. So at this point, I think we can begin with Attorney Erdman for the city, and we can set up a timer. Perfect. To manage that time.
Look at Marty.
Yeah.
Timekeeper?
Yep.
Thank you, Marty.
Tell me when. All right.
Whenever you're ready. Yep.
Okay, thank you. All right, so as Attorney Bunger stated, we're going to go through, have some testimony from the officers, and ultimately, we think that the testimony is going to show that the appeal should be denied, that the residence does qualify as a chronic nuisance property. So I'm going to start with, I'd like to call Officer Joe Johnson to testify.
You can go there.
You know what? You want to just sit here? Yeah, just sit here.
Officer Johnson, if you would please state your name for the record and raise your right hand.
Officer Joe Johnson.
Do you swear or affirm that the testimony and evidence you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Officer, could you state your place of employment and your position there?
I'm a police officer for the City of De Pere Police Department, and my role is as a community policing officer.
Okay. And as a community policing officer, are you tasked with dealing with problem properties?
I am.
Okay. And you deal with tenants and ownership at certain complexes as part of that?
Correct. Throughout the city on the west side.
Okay. Now, I'd like to go through the nuisance abatement plan. That's the mostly what I'm going to go through here as far as the operative document. Are you familiar with this nuisance abatement plan?
I am.
Did you help initiate this nuisance abatement plan for 1380 Shearing Road, unit number 24?
I did.
And who's the tenant at that property?
The tenant at that property is Rachael Carriveau and her 3 children.
Okay. Now, ultimately, did you sign off on the nuisance abatement plan?
I did.
Okay, and you reviewed it with Ms. Carriveau?
Correct. And management of the property.
Okay. Now, I wanted to go through the essentially the makeup of the plan is in this case 4 separate calls. Is that correct?
That is correct.
Okay. I wanted to kind of just work down each call, starting with the first call. Can you recall the date of that?
I can. Would I be able to
Yes.
review my report?
Yes.
Okay. So my role as a community policing officer is each day when I come in and start my shift, I go through the calls that we have from the previous shift or shifts, previous 24 hours, and then just basically take note of addresses I see repeatedly show up for call volume. The first call that I was looking at in regards to this address was dated according to the responding officer's report on October 24th, 2025.
Okay. And I think you mentioned this, but so this is a regularly conducted activity where you review these on a day-to-day basis as part
Correct.
of your job. Okay. So for the October 24th, 2025 call, could you describe the background for the reason for the call?
The call initially started out as a mother-daughter disturbance. The officers responded and found out that the daughter had fled from the home and was located near Westwood School on Westwood Drive on the west side of De Pere. and made contact with the female at that time. They eventually were able to calm her down and find out what had transpired. Brought her back to her parent, Ms. Carriveau, and then referred that case down to Child Protective Services based on the concerns that they observed or were informed of by her daughter.
Okay. Ultimately, how would you characterize the reason for that call? What type of activity would you characterize that call as?
I would say under state statute, it would be disorderly conduct.
Okay. Would you consider or include truancy as part of that call, or specifically disorderly conduct for that one?
For this one, it would be after school hours, so it would have been just
Okay.
disorderly conduct.
Okay. Did you, were there multiple officers, if you're aware, that responded to this call?
There were, on any disturbance call, we have a minimum of 2 officers. With this one being between the residents as well as the school, there were multiple officers involved in that one incident.
Okay. Was Ms. Carriveau warned either verbally or in writing as a result of this call?
Typically, in a disturbance call, we would issue a warning to cease the behavior, but this one also included the referral for at least a look at the residents and the situation by Child Protective Services.
Okay.
For potential welfare concerns.
Okay. So there was a referral, and regularly you receive a written warning for, or not a verbal warning at minimum for this type of disturbance. Okay. Let's go to, is there anything else you wanted to say about that specific call that we have not discussed?
Nothing further on that one.
Okay. Now, I'd like to move to the next one, which I believe, do you recall the date of that one?
Again, in reviewing the reports, it was identified on December 12th, 2025, that there was another disturbance at the address.
Okay. And could you describe that disturbance just generally, and then we can sort of get into the specifics of categorizing it?
So on this disturbance, it was, again, Rachel and her daughter, and the disturbance ultimately stemmed from her not wanting to go to school. It was during normal school hours. When officers arrived on scene, they didn't hear anything outside the door, attempted contact for a period of time. Eventually, the mother came to the door, wasn't really focused on what the officers were talking with her about. They said that the officers reported there were signs of a disturbance inside the home with property in unusual places. And in that one, we had to pull a school resource officer from the schools. He's the one that manages the intermediate school, middle school, and Westwood grade school on the west side to come over and assist because there was a good rapport with the parents and that officer so that we could transport the juvenile to the park and ride on Main Avenue to turn custody over to her father.
Okay. So ultimately, how would you categorize the call from December 12th?
On that call, we would again have the disorderly conduct with the disturbance, but it was also during the hours of school, which falls under our ordinance of truancy prohibited.
Okay. And do we know if Ms. Carriveau was issued a warning on that particular call?
According to the officers' reports, again, they were talked to about the disorderly behavior and working to end that. Mm-hmm. We typically try to work and educate the families in those types of situations versus taking immediate enforcement action in the lines of a citation or an arrest. So there would have been some educational aspect in the form of a warning.
Okay. Verbal warning again on that one. Okay. Anything else that you wanted to discuss on that specific call in December?
Just to give you a quick heads up, we're around 2 minutes right now. If you need more time, that's fine.
Okay.
And we can give that to you, the council can approve, but we also have to give the time addition to Ms. Carriveau as well. So
Yep.
just giving you a heads up.
Thank you. Yep. Anything else you wanted to say for that call?
No.
Okay. Now let's move to January 7th, or I'm sorry, the third call. Could you state the date and just go over the overview of that call?
That one was on January 7th of 2026. That one came in as a report of possible child abuse based on a bruise that was observed by the child's father on her person. Multiple officers responded, but no contact was made until later. That case also involved investigative follow-up, work with Child Protective Services, the Child Advocacy Center, or Willow Tree. Ultimately, an investigator conducted his investigation and ultimately ruled the incident unsubstantiated.
Okay. So then how would you characterize that call ultimately?
So again, with that one, a Child Protective Services referral was made as our enforcement action.
Okay. Would you say that's a disorderly conduct categorized call or potential battery?
At a minimum, disorderly conduct.
Okay. And it sounds like with that call, generally education, verbal warning at that point with that type of call? Okay. Now, the last call that I wanted to review with you was, could you give the date and then just a general overview of that one?
Of course. That last call was on the 13th of January, 2026, when again officers were sent to the address for a disturbance between the mother and daughter. This incident actually started with a call being made directly to the school liaison officer, who was on his way to the school for his normal duties. Okay. Initially, the parent declined to have officers come over. Again, the disturbance was for the child not wanting to go to school, but it had then turned into a physical disturbance. Eventually, the mother contacted the SRO again.
I'm going to just have to stop you right now. I'll make a motion if it's okay with you, and 5 minutes is enough, to extend your time by 5 minutes.
Okay.
I'll second.
Motion by me, seconded by Alderperson Ledmana. All those in favor say aye.
Aye.
Aye. Opposed? Motion carries. Thank you. You've got 5 additional.
Thank you.
And then 5, yes. And then 5 additional for Rachel if she needs it as well. Thank
So
you.
eventually 911 was contacted. Multiple officers responded to the address. Upon their arrival, there was contact made with all parties involved. There was also an odor of marijuana detected, which initiated an investigative response by one of our detectives who has experience with the Drug Task Force to look further into the concerns about drug use in the address. The odor was confirmed. The detective spoke to Rachel about the concerns with the drug use in the apartment. She denied that there was anything in there, but was ultimately notified that if future calls took place at the address involving the drug odor, that a search warrant would be requested through the Brown County courts, and then a search, if it was approved, would take place of the residence. In this case, a citation was issued to the daughter for truancy prohibited.
Okay. And it sounds like, would it safe to say the categorization of this call ultimately was like a disorderly conduct and then truancy as well?
Correct.
Okay. Anything else that you wanted to mention on this particular call that we have not discussed?
No, on this call, again, we have Child Protective Services also involved with a referral. We've had multiple officers involved in this last incident, which then carried over to the shift supervisor being tied up for a period of time responding to phone calls from parents or parties involved. Ms. Carriveau, her ex-husband, tying up a lot of city resources between police administration, the officers in patrol, Child Protective Services, also the courts in the past. So.
Okay. And so you discussed this with management at the facility as well? And
Correct.
signed the plan? Okay.
Yes, we have a good working relationship with the management there and want the neighborhood to be in proper fashion.
Okay.
Going backwards.
Yeah, we're going backwards.
Those are the questions I have for Officer Johnson at this point.
All right. Any other testimony or any other?
If briefly, I'd call just Chief Moraski.
Perfect.
Sorry.
Get sworn in.
If you would please state your name for the record and raise your right hand.
Jeremy Morosky.
Do you swear or affirm that the testimony and evidence you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Could you state your place of employment and position there?
Yes, I am a police officer for the city of De Pere. I am currently blessed to be the chief of police.
All right. And as part of your duties, specifically with this ordinance, you have discretion to review and ultimately notify somebody that they may qualify, their property may qualify as a chronic nuisance.
That is correct, yes.
Did you review the nuisance abatement plan that we're here today on?
Yes, I did.
Okay. And did you authorize that and agree with that plan?
Yes, I did.
Okay. And did you believe that you reviewed each call as well as part of that? Did you believe that the each call that was a subject of this plan reached the threshold of nuisance activities?
Yes, and there were other calls as well, but those were the four of the primary that you had identified with Officer Johnson.
Okay. So you felt like in your discretion that met the criteria for
Yes,
this?
that is correct.
Have there been other instances where other properties may have met the threshold for a nuisance, but you decided not to issue that plan in your discretion? Or could you maybe delve into, what made this one maybe a little bit different, even though, it qualifies, but then going that extra step to the plan?
Yeah, typically, we don't like to jump straight to a nuisance abatement. If it's just 3 calls that happen to qualify, we try to give people, a chance to remedy these situations. In this particular case, however, in addition to the police calls for service, there was also a lot of burden placed upon the police department supervisors, the police department administration, myself, and the professional standards captain, because in many of these cases, there were follow-up calls that were made by the parties involved that were either making a complaint or insinuating that we didn't do enough for that call and things of that nature. So in addition to the normal response from all of our officers and the school resource officers and the CAC and Child Protective Services, myself and my staff also spent many hours reviewing those calls for service as a result of those conversations.
Okay. And so it's your position that, you're asking for the council to deny the appeal?
Yes, very much so. It is representing a very...
My apologies, we're going to have to stop right there. That's the 5 minutes. Obviously, you're not done, so I'll make a motion for another 5. Motion by me, seconded by Alderperson Gantz. All those in favor say aye. Aye. Opposed? Motion carries. Thank you. We're at 5 more.
Did you want to just continue, Chief, with that line?
Yeah, just to indicate that it was a very disproportionate amount of services that we have been dedicating to this particular apartment at this particular address, even compared to the other apartments at that particular complex. That particular complex has, over the years, been a significant burden on the police department, but this apartment, based on the amount of time and energy that we have spent there, really stuck out.
Is there anything else that you wanted to say about the plan or the process at all at this time, Chief?
Not that I can think of.
Okay. I don't have any further questions for Chief at this point.
Okay, great. Any other comments, Attorney Erdman, you'd like to present at this time, or reserve your time for rebuttal?
No testimony at this point, so I'll save any argument or closing that you'd like for the end here. So.
Okay, great. All righty.
Thank you.
Now, next we would invite up the appellant, Ms. Carriveau.
She has 16 minutes.
Yep.
Should I do that? She gets 20. She gets 20. Okay, 20.
Yeah.
You want to tell her that, or am I telling her that?
I can tell her that when she gets situated. All right, we can get you sworn in by the clerk, and based on the time used by the city, you'll have 20 minutes to be able to present evidence, testimony, as you wish.
If you would, please state your name for the record and raise your right hand.
Rachael Marie Carriveau.
Do you swear or affirm that the testimony and evidence you are about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can begin.
I brought along today all of my court custody case that was initiated in Marquette County, Michigan, along with the previous police reports from 7 years that I lived in Green Bay. In those 7 years, had over 100 police calls to my home initiated by the other parent of my children, Jacob Joseph Klechka, who goes by the alias Israel. I also included all of the CPS reports that were initiated mostly by Jacob. However, some also perhaps by the school where my daughters had gone. And I currently had already had 35 CPS investigations, along with those over 100. A lot of them were welfare checks, but some ended up starting to be at, or for keep the peace at the exchanges. So I also included, these are the documents that I believe everyone should see right here, this from this record, although today I just went and was able to pick up another 28 CPS reports from recently since I have moved. There has been some issues that I've tried myself to come in and notify the police that I needed help to deal with based on the things that Jacob was willing to lie about. And one of those things is the previous court order when I requested my records for these reports. They kept the law, or they put in the most recent court order. However, I have from 7/24/2023 a page of of a court order that says Mr. Kletchka must stop calling the police during custody exchanges and at extracurricular events of the children. I should have counted these, numerous reports immediately made after on 7/25, 7/27/2023, these are all 2023, 8/12/2023, 8/13/2023, 8/24/2023, another one, 8/24/2023, 8/26/2023, 8/27/2023, 11/3/2023, which in this report, my daughters and I had actually moved to this address a little bit before November of 2023. And however, I kept my daughters at the Green Bay School because my daughter was in orchestra and she really wanted to be able to do her orchestra concert at the school. However, this report says Jacob was driving his vehicle and changed lanes and hit another vehicle. And I can absolutely show with lots of evidence that he gets very agitated and he's just been willing to lie about so many things, including lying about several people with sexual assault to my children. And I understand that the DPR police have also initiated a case report from a sexual assault. The first, I have emails in here from the two attorneys where Jacob was accusing those attorneys of taking money and allowing my daughters to be molested. I actually have the investigating officer who investigated him.
Ma'am, just really quick point. So just want to just ensure that you're using your time wisely. The matter that
pause the
we're
time?
here, yes, we can pause the time.
Okay.
The matter that we're here for that we're asking you to address and that you're appealing is specifically the 4 calls that the city presented as being the qualifying calls for the chronic nuisance determination. I understand that there is a lot of backstory with respect to history with custody issues and so forth, but if you can focus on essentially your arguments with respect to whether you think that the determination was reasonable or any other information or facts you think are relevant with respect to those 4 calls that led to the chronic nuisance notice determination, and whether you think that and the reasons and the arguments behind why you think those should be overturned.
Sure. I do think it is, however, very obvious that Jacob has just been lying and that the police do not know all of the things going on. So I feel like this is still all very relevant. So these are the reports from the time from about 4 months when I moved. As I just listed all the dates, you can see that he refused to stop calling the police. So then I was able to get all of these are the DPR reports from when I moved, and then these are the CPS reports that I received today, 28 of them. So since you'd like me to focus on that, I would like to make notice that I was never issued any disorderly conduct. And even though this says that I was given a warning, I was given a warning on the very last call, and let's see, when I moved into my unit, I had made aware the office know that I have already had previous 100 calls in Green Bay, and they let me know that there's a law that protects women if they're being abused, and unfortunately, the police had told me that it was not domestic abuse because it was my child who's doing that. However, in this CPS report that I very quickly only got to go over, I did find that my middle daughter, Ruth, had said, not only to the CPS, but me and my friends as well, as I have an identical twin sister as well. And she made these comments to my sister and I that Jacob is encouraging my daughters to misbehave. Since I moved to De Pere, my daughters have not really wanted to go to school, and I think that is because they wanted to continue to go to school with their friends. However, there's just my daughter at that, my oldest daughter, who is also Rachael, had been halfway through her school career. So I had thought, actually, I was able to move in the same unit as my twin sister. She moved there first, and then I was able to get a place 5 doors down from her. And I think it is reflective in that even the office, my daughters have told me that while they were with their dad, or he wants to be called Papa, that he has even called the office finding out how many police calls needed to happen before I would get this plan. And now in my lease, it says if a person on this property receives a nuisance of abatement plan, that we automatically get a 5-day notice for 5-day notice to vacate. Again, I said, as I mentioned, I only received one warning on the final call, which on the 113. On 113, and I had started to video record myself, so I'd actually asked ahead of time to say, I didn't think I was going to be able to prepare everything in advance for today. However, I do have that, as I also have recorded the entire nuisance of abatement meeting with, Officer Johnson. In that meeting, in his abatement plan, they gave me the law they have to follow. And it says that they are supposed to meet with the property owner first. And this was during the time that it was the freezing cold and all the schools were canceled. So I asked him, is this the first meeting that you've had? And he said, well, we meet practically every day with Nicolay Townhomes. Therefore, I think really proving that I am not the only reason that they are getting calls there. However, it requires a meeting first with just the property owner. In the law here, I'm sure I can find it, but I'm sure maybe you are all aware, maybe not. Once they have that, once the property owner is served with those papers, he has 5 days to have a meeting with the officers to create this nuisance of abatement plan. However, it does say that the nuisance of abatement plan is to be written by the property owner, which I specifically asked Officer Johnson, did you write this, or did the property owner write this? And he said that the police write the abatement plan, but that is not what the law says. It says that the property owner is to write the plan. And so after the 5-day original, which they said that this was their first meeting with me in the office, I was supposed to be given an extra 10 days to have this meeting, and that would have made it past the point of that freezing day. So I didn't really know the process of this, so I did start attempting to move my stuff out. However, I've since contacted an attorney, and he said, you need to stay because the police have not followed the proper procedures, so there is a merit issue. On top of that, even in this plan, like I said, I recorded my conversation in the office with Officer Smith and Amy. And in his plan, it says that right here it says, quote, I discussed the legalities of the ordinance with Rachael Carriveau and Van Elzen. They indicated that they understood, and I very clearly indicated that I did not understand, because from what I understand, I would have needed to be cited for any one of these nuisance activities. And although they're considering that disorderly conduct, it was really my daughter who was physically attacking me. So on the day that my daughters ran away, my daughter actually started pulling my hair, and she ended up starting to choke me with my own hair. And my daughter, I had to leave Jacob when she was 2 because she started calling me names that he had also called me. And so he's really been out of my daughter's lives for all this time, except for he started petitioning the court in 2019. However, all family court was shut down in person so that none of my evidence got presented. And even with the guardian ad litem knowing that Jacob is willing to lie about these false sexual assault claims, I think I was the 9th person that he tried to lie about. Since this has started, he's even now starting to say that children are assaulting my daughters, which is not true. I would never even hurt my daughters. In fact, I realized in one of those, it was a closed case. The guardian ad litem absolutely knew it was a closed case, yet when it got brought back up in court, he said it would have to be something I look into. However, which one is it? The one with the bruise with my daughter, Jacob actually had my daughters right before that for, I think it was 6 days. And when I did not even notice the bruise. In fact, I thought it was a little bit of dirt. I did not know. But I've had several calls. In fact, I believe that this police department should be charging Jacob with false police reports. And in fact, that as this officer just stated, that he is lying to the police because him and I were never married. And they are under the assumption, just like he lied in the court, saying that we were married, but we never were legally married. In fact, I met him, and I left to California with him only about 2 months later, which might not be the best idea. However, everything happens for good. And so I would never take away my daughter. I would not want to not have my daughters. My daughters are Rachel, Ruth, and Rebecca. And I just believe that a lot has really gone wrong here, so that this should be, besides the merit issue of not giving me the extra 10 days. And I just think that they knew it was in my lease that I would be evicted immediately. However, my attorney, as I mentioned, he said that there are absolutely merit issues, that the police did not follow the correct process on this, and that I should stay. Which is another reason why I decided to appeal this decision, because I was never cited with any disorderly conduct. And although the police are saying that I was warned, I was never warned, except for on the last day, and I recorded that with the school resource officer as well. I have that conversation in my home of me telling him that they cannot, I don't want to be calling the police. In fact, since this has happened, my daughter has tried to pull my hair again, and I just know that she's so confused by being told by her dad to misbehave and do these things because she just wants me to move back to Green Bay. And that isn't even something that she really wants, because I live right by my identical twin. And she has a four-year-old daughter that my daughter just loves to be around. She'll try to go over there, and that at one point has generated a call because my daughters had ran away over there. They were lying to even my twin, saying my mom's hurting me, and even some of these CPS reports are very misleading, because I asked my daughters if they ever said this, and they never did. And the CPS reports are even more misleading, because there is another Rachael Carriveau. In fact, I graduated from DPR High School in 2004, and the other Rachael Carriveau graduated in 2003. And what makes it even more of a mix-up is that we are both identical twins. Me and Rachael Carriveau, my twin Renee Carriveau, and her twin Rebecca Carriveau. So Besides the merit issue, I do not believe that this officer is being honest as far as what's going on with saying that these disturbances should be considered disorderly conduct. I was never warned or talked about this. In fact, my daughter has even said with this truancy that the principal has come to her and said that the school resource officer has not followed the proper procedure because he is supposed to notify the principal before any of this happens. And so it just seems like a lot of the process has not been done correctly. I never have a need to defend myself against lies. However, there are just so many lies involved that I don't even think that I need to defend myself, because I know who's really defending me is that, and has kept me safe throughout all of this. But as I was mentioning, there's more of a mix-up, and I've already tried to tell CPS, because the other Rachael Carriveau actually has 2 OWIs. I have never had 1 OWI. However, that is in every single one of my police reports. And as I can look in one of these, it should have been very obvious to CPS, because instead of for Jacob's previous criminal record, it says 1997 battery dismissed, 1999 possession of switchblade, 2001 disorderly conduct, 2001 divorce, 2003 theft, 2004 bail jumping, 2006 eviction, 2009 interfering with custody dismissed, 2020 in RE the paternity of RMC. So that would have come up on my record as well. However, they instead just put family court, and Rachael Carriveau, the other Rachael Carriveau, has a different middle name. However, and also I have an extra A in my name. My name is spelled Rachael, not Rachel like the other Rachel. And then as I personally know her, I just find it very odd that this would have happened, especially because I corrected it, and it just has not gotten corrected. Another thing is, as I read that off, I did not look his name up on CCAP before I left, which is something I also have been slightly a mistake. But like I said, I love and adore my daughters. It is so disappointing to have my daughter be physically attacking me. They've had to go through numerous counseling. In fact, the police are slightly interfering with child custody, encouraging my daughter to disobey me, because at the 12/12, my daughter had pink eye.
Rachel, I'm sorry, but so you know you have 2 minutes.
Okay. My daughter had pink eye on 12/11. She was not able to return to school until 12/12. She was only going to be going for an hour. Now, because Jacob has caused such conflict during the exchanges now happen right after school. So my daughter was trying to have me just wait until after school, and I said, well, that's not going to work, because he just constantly is lying and constantly bringing things up, making up lies and making things. So I said, you only have to go back for 1 hour. And she would not go. And so she started physically hurting me, attacking me. She has held up scissors to me. And I understand that Wisconsin law allows a person to call the police if they're being physically harmed or threatened. And I never wanted to call the police on my daughter. And the day that she did hold up scissors to me, threatening me, as soon as I called and hit 911, she said she was so sorry. And the look that I saw as her mother was just, I was so sorry that any of this had to happen. Because I named all of my daughters after me. Rachel has my first name, Ruth has my middle name, and Rebecca has my last name. Sorry. So I just do not think that any of these things should be held against me or my daughter as disorderly conduct, as we were never given a warning or told that this would be disorderly. Besides that, they tried to evict me during the cold, where it was minus 18 degrees. So I just really think that this should be considered, since I have, like, as I mentioned, that I've tried to come to the police and show them my records. Since Jacob has gotten 50-50 custody, which is not actually how the legal process is supposed to go. I was granted full legal and full physical custody in Michigan in 2015 of my daughters, and they have since found themselves in inconvenient forum, but they have held another hearing. At that last hearing, I said, you are leaving my case in limbo. You cannot leave my case in limbo. However, because of the process, there really just has been a lot wrong in this process. At this time, I have reason to take Jacob back to court for contempt and prove all of this. However, I have been now consumed with putting all of these records together. I have not even had a chance to, I can't even page through some of these.
My apologies, Rachel, but our time is up. You'll have a chance to do a rebuttal. I think right now Attorney Erdman will speak.
Yes.
And then we'll go back to Rachel as well. Two things come up here that we can ask questions. Obviously, one would be the proper notification. Was she notified properly? And I guess, are we dealing with the proper Rachael Carriveau as well in the proper apartment? Are two things that kind of come up that's pertinent to the case. So Attorney Erdman, you want to go first?
Yeah, if we want to talk about the correct identity, we can address that if you'd like. Officer Johnson, do you want to comment?
I would definitely like that.
I think that's the two things. And if you guys have something, let me know, okay? You do? Okay. Okay.
All right. Still under oath, so can I start going ahead? Questions?
Yes, you may.
Okay. So I think one thing Ms. Carriveau has mentioned is that she's talking about a mistaken identity. For the subject of each one of these 4 calls, can you confirm that Rachael, the appellant, was one of the subjects of each call?
So looking at the police reports, and also attached to the reports are the details dispatch puts in the computer system when a person's first name, middle initial, last name, date of birth are run through the system. That's attached to that report. It is not linked with my nuisance abatement plan, but if we get the full all-encompassing report, it includes those, what we call CAD notes. So her identity was verified on all of these incidents.
Thank you.
Okay.
Alderperson Hanson has a question. Alderperson Hanson.
Yeah, I'm just wondering about, the ordinance does say that the abatement plan is prepared by the property owner, and that was something that was brought up. So just wondering if we can get a little more discussion on how the abatement plan was prepared.
Sure. So the abatement plans, especially with that property, we do hand in hand with management at their request. So meetings take place often when we see a trend at an address. As indicated, we have a higher call volume at this complex than others, so many conversations took place leading up to the meeting with Ms. Carriveau. And during those meetings, the conversations took place between the on-site manager, who consults with her district manager, who's based out of Oshkosh, as that plan was put together, and it was put together with their direction as well as us ensuring that the needed information was listed.
Good. Thank you. Anyone else have a question while we're here with the attorney? Alderperson Cuniger.
Yeah, who outside of the one?
Sorry, can we pause the timer? I just want to preserve time for the attorney to have any additional arguments if necessary, but we can go ahead with questions.
Who, outside of the one call that Rachael has mentioned, who initiated the other of the 4 calls?
Of the 4 calls?
Yes.
So one of them was ultimately initiated by one of our school resource officers, so he made the initial notification before she called 911 after telling him not to come over. We also had the child's father as the complainant in one incident, and the others were Ms. Carriveau calling.
Are you good? No. All right.
Mayor?
Who's up next? Alderperson Hanson.
Yeah, I just had one follow-up on that. It does say in the ordinance that that it shall never count nuisance activities that were reported by the owner of the premises. So I'm just wondering how that fits into who initiated the calls.
Is she? Yeah, I mean, is she the owner of the premises?
She is a lessee She is not the owner of the premise. That would be ACC Management or the Nicolay Properties.
And so as far as we know, the owner did not initiate any calls.
That is correct.
Good.
Yep.
Anyone else have any questions?
Oh, right here.
Alderperson Ledvina.
Do we know what the cost is associated with the calls and the nuisance?
I personally don't.
Do you want like are you interested in like the amount of hours on each call potentially, or like in terms of like, like how many officers and how much?
I
that
mean, the whole point of this is that we are able to essentially bill her for what your department has undergone. We don't have that information yet?
Well, so once this plan is in place, anything after that is when the assessment financially would take place. So leading up to the placement of the plan. So the plan is put in place. I met with Ms. Carriveau with management. All parties signed the plan. And then that plan, then there is a window of time that has to transpire where even if there are violations, we cannot cite for chronic nuisance, which would be toward the property owner, to allow remedy and corrective action to take place. And then after that time period, the count starts for the time.
Okay, thank you.
Alderperson Nelson.
Yeah, just to be clear, so there was no citations issued during those 4 calls, is that correct?
There was a citation issued by a patrol officer, not the school resource officer, for a violation called truancy prohibited. We have 2 truancy types, habitual and prohibited.
Sure.
Habitual is cited by the school resource officers based on school attendance. If a child is outside of the school building during normal school hours and they're getting in trouble or not at a doctor's appointment, police officers outside of the schools are capable or able to cite for that prohibited truancy violation, which is what the daughter was cited for on that last offense.
Gotcha. And the ordinance doesn't require any citations, it's just calls that are deemed nuisances. As long as there's 3, then it could potentially qualify.
Correct. So it does state enforcement action along the lines of a verbal warning, written warning, citation, or arrest.
Gotcha.
It doesn't have to be in full written form.
Yep, makes sense. Thank you.
Thank you. Alderperson Carpenter.
So the citation the daughter was given, that automatically goes against the guardian?
The citation is issued to the child in their name, and then they would have the ability to appear before the municipal court judge for the judge to make a determination on either monetary punishment or some alternative punishments. It does not necessarily fall on the parents. The judge is creative with his enforcement.
Sure, thank you.
Okay, you can restart the clock. Anything else you have? Attorney Erdman?
Not for Officer Johnson at this point.
If you have any final arguments or anything else you wanted to present to the council.
Yeah, if it's a good time for closing, I can just kind of summarize what I think the testimony has been and kind of get into the ordinance a little bit. So as was referenced at the outset, this particular ordinance has a policy finding, and it's the Common Council finds that any premises that has generated 3 or more calls for police service for nuisance activities has received more than the level of general and adequate police service and has placed an undue and inappropriate burden on the taxpayers of the city. Therefore, the chief of police is directed to be able to charge the owners of such premises the costs associated with abating the violations at which these nuisance activities chronically occur. So before that can happen, there has to be put a plan in place before the cost can be directly assessed, just to clear that up as well. I know that Officer Johnson touched on that as well. So really, we're talking about whether the first step is whether or not there were 3 or more calls. Clearly there were. Their testimony was that there were 4 calls. Now, there has to be nuisance activities, which is defined in the ordinance, including but not limited to disorderly conduct, battery, and then truancy. And it was uncontroverted that of the 4 calls, the first one in October 24th was generally categorized by the officers as a disorderly conduct. The December 12th call was categorized as a truancy and disorderly conduct call. The January 7th was disorderly conduct, possible battery, but generally disorderly conduct. 4th call was a truancy and disorderly conduct combination. fourth call actually did lead to the issuance of a citation. The first 3 calls, the testimony was that there was at minimum a verbal warning, two of those 3 calls included referrals to CPS. So that's important because, enforcement action under the ordinance means the arrest, as the officer said, arrest, the issuance of a citation, or the issuance of a written or verbal warning. So we're not really getting into the guilt or, in a sense, of, each one of those calls. Essentially, it's, warning can qualify. So I think it's uncontroverted that, the nuisance activities as defined by the ordinance were met in each one of the 4 calls, even though 3 of which included warnings and/or referrals to CPS, one of which was an actual citation. So I think the steps as far as nuisance activity was met as well. So with that being said, I think that the chief had suitable discretion in order to initiate this process, in which case testimony was that Ms. Carriveau, the owners, and the police department reviewed, prepared, and ultimately all signed off on this plan. So we think all the elements were met here. And again, I would encourage you to think through each of the calls specifically, not necessarily some of the collateral information that Ms. Carriveau brought up as far as some of the history, some of the conclusions that she brought up, as far as some of the other some other calls in history of some of the other indirectly involved parties here. So we do think that clearly the nuisance, this is exactly why this ordinance exists. There's testimony to, the amount of officers that have been called and the resources that have gone to this place up to this point. So we would encourage you to deny the appeal and uphold the finding that this is a chronic nuisance property going forward.
All right, thank you. We can now move to Ms. Carriveau for her 5 minutes, if we can have that up, and you may go. And if there's any questions, we can pause and deal with the questions as they come up. You may proceed.
So as I mentioned, that when officer was trying to present this abatement plan, I had said the law does require the property owner to do to write it, and that he asked me. I did not actually read through the abatement plan. He was just going over, and I said, he asked me, "Do you understand the law?" And I said, "No," very clearly, as I mentioned, that I have that in my a recording device. So afterwards, I did go through and I did look up these statutes, and I did not feel like that any of the calls met either the disorderly conduct as as this attorney is claiming, but also I'm very actually glad that he just officer brought that up, because about the truancy is because my understanding when I read this, what this is that truancy is defined in this section is habitual truancy. Therefore, it would have needed to be written by the school resource officer, not just another officer. However, as I mentioned, my daughter's just been encouraged, actually, as this gentleman had asked the question, my daughter has been persuaded by her father that I would be getting the citation. I would be the one getting in trouble. And she came to me after having the information from the principal telling her that he was going to try to get it thrown out already because the process wasn't followed. That she told me that she did understand then that it was not me and that she did feel betrayed, that she was lied to, again, by Jacob, making her think that I was going to be the one getting in trouble for this. And I just do not think she comprehended, because she has lied for Jacob. And that is what has happened again, as all I can really comprehend about this myself, because I thought that it would be abundantly clear that I've been trying to deal with some things. And even when my daughter did get turned over by the school resource officer on the December date, I was trying to mention that it was because she had pink eye. She was supposed to return to school, and instead she got dropped off at she told me, the festival parking lot with these eye drops that she needed. However, that was, I feel like, giving her another feeling that she could just disobey me and get away with not going to school. So I feel like the school resource officer should have understood she needed to go back to school. Another thing is that there was no provisions in my court order if my daughters had medication. However, I feel like they should have considered all of this because there were so many issues with the exchanges that they have refused to take the medication for me at school. However, I just recorded myself and the principal this I think it was this past Friday, handing over some medication dropped off by the grandmother. And I understand that the school is not supposed to take, because they have refused to take my the medicine from me. And that even the officer, I understand he was trying to be helpful, but he should have brought her back to school instead of going with Jacob. So she has been just really misled. My daughter Rachel has been misled to be disobedient towards me, thinking that it's going to get, and it has, as I mentioned, that in my lease, if a person on this property gets a nuisance of abatement plan, that is an automatic 5-day notice to vacate. And so I did not know the process, and so I did empty as best I could all my stuff. However, it was just too short of time, and then once I talked to the attorney, and I felt like that everybody here would be very understanding about, like as I mentioned, I have already 100 police calls in the 7 years I lived at Green Bay. Those were not initiated by me. However, I understand the ones here have been, but that was for my safety because I was being physically harmed by my daughter, who I just believe is really confused by Jacob. And I wanted to clarify too, it was the CPS reports that have me mixed up with the other Rachael Carriveau. And although one of these reports say that they've reached out to me, I have had no contact. In fact, I've been waiting for CPS to come back to my house because in these, I think there was 35 or 37 reports within a year, or maybe 2 years. They stopped coming, basically, and once they stopped responding to Jacob's reports.
Okay, Rachel, you do know you have to finish up.
Okay.
I'll give you about 30 more seconds.
Yeah, he started making lies up about my sister and her, and the same individual that he had already lied about regarding sexual assault. So all of it's just, he's willing to lie about very disgusting things, and I have all the evidence. I've been just trying to do with getting it back in court, and I've been in court illegally and not following the correct process, even in Brown County Court.
Thank you. Joanne, thank you.
Yes. If there are any questions?
Any questions, Alderperson Carpenter?
Yes. On this abatement plan that you signed, you did sign the abatement plan, am I correct?
They had me sign 2 copies. However, I did not notice that he had wrote in there that he discussed the law with me, and it says that I understood the law. I very clearly told him, no, I do not understand the law. So even though he had this written up ahead of time, I did not, like my copy is not signed, the one that I have here. And mine's not signed,
Well,
that I have right here.
I guess the question I was having for you, you stated how you didn't understand anything and all that. So I'm just trying to figure out the rationale. If you said you didn't understand why you would sign something, this is what I'm just trying to figure out.
He told me I had to sign the nuisance of abatement plan.
Okay.
Yeah.
Oh, thank you.
Anyone else have any questions?
I do.
Alderperson Gantz.
Are you still living at the property?
Yes.
And has your landlord filed any papers against you to vacate?
Yes, they put a 5-day notice to vacate, and then right here I have a summons and complaint for small claims eviction as well.
And what is the basis? The nuisance order?
Yeah, it is.
Do you still have custody of your children?
Yes.
Partial, full?
I originally, like I stated before, I had full legal and full physical custody granted to me by Marquette, Michigan, which should have been upheld. In 2022, he was granted 50-50 custody in accordance with the Wisconsin state statute that it is in the best interest of the children to have 50-50 custody. However, actually 2 weeks after that, in Marquette, Michigan, he assaulted a police officer. And even my youngest daughter, Rebecca, has been telling me the things that he said to her that he told the officer that's in my report. I do not want to repeat it because everybody can just look at the report for themselves. However, he should not be talking to my children in the way that he is.
So you do have custody full-time?
Yes.
And do you have an attorney representing you now, and are they here?
I looked into getting, through legal action, an attorney for the eviction hearing. There is no legal counsel through legal action in Wisconsin for child, even though it's actually on their sign that they have child custody help. I did have child custody lawyer in Michigan on the original case in 2015. And I petitioned before my youngest daughter was even to be born for Wisconsin to take this action, and they did not follow the process on that they were supposed to send the entire transcript. And they actually found that until both parties left Michigan, they could not give the jurisdiction to Wisconsin. However, in Michigan's own record, Jacob had already left before the initial custody was determined. He had left to Florida. And then I ended up getting a job in Florida because I did talk to some attorneys then, and they advised me by basically saying that with their particular experience with the judge up there, that if I could make it possible to let my girls see him, that I should. So I decided to take a job offer in Florida. And
Okay, I'm
yeah,
sorry.
I'm sorry.
mean, do you have one right now? Because earlier you mentioned that you might have one.
I'm waiting for him to review this, although he doesn't have the CPS reports. I did hand over everything that I brought for all of you to look at. He has not called me back. However, he did tell me that even if he could not represent me, there is something called ghost writing, that he would still be able to write me a ghost letter, and that he just advised me that there is a merit issue with them not giving me the extra 10 days. And so I just really feel like that this should be obvious that I've needed help in protecting my children, and that all of the things put in place are just not doing that. And I tried to take this and show them, because I think that any officer who would read this assault of a police officer, or even the other things Jacob has been charged with, since he's been actually somebody ran him over and broke both of his legs. My daughters told me that that same individual has been threatening them while they're up there. So I've been tirelessly working to try to prove all of this through Brown County Court, and I just have not had the opportunity, especially every time I would go to work on this. That is really when my daughter would start attacking me. And I also believe that she was influenced by that from him, because she wants to move back to Green Bay. But she doesn't want to be away from my twin either, or my niece.
Thank you. I appreciate it.
Thank you. Any other questions that we have? Alderperson Carpenter.
And could you just give me the age of that daughter?
She just turned 14.
Thank you.
Thank you. Other questions that we have? All right. I do believe we're done now with the testimony.
Yes. And if there are no other questions for either of the parties, we can move into closed session for deliberation.
All right. Please take notice that the council will convene in closed session pursuant to statute 1985 LA, Wisconsin statutes, for purposes of deliberating concerning a case which was the subject of any judicial or quasi-judicial trial or hearing before the governmental body. The council will thereafter reconvene in open session pursuant to section 1985-2. For the record, we're moving. Everyone else can stay here. To take action on items discussed in closed session, if appropriate, and to consider the remainder of the agenda. I'll make a motion to go to closed session. Motion by me, seconded by Alderperson Conacher. We need a roll call vote, and we will be moving. You all can stay here.
Excuse me, I also did want to just give this all to you as my evidence. I don't know how relevant it would be, but it is just...
Are those the CPS reports?
No, this is not any CPS reports. This is all of the DPR police, and just the court order stating he is to stop calling, and just a few before I moved here. And this actually says that he called. I have 28 calls in 2023 as of August.
Would you mind just bringing that up?
I would
and
love
I
to
can
give it
take
to
a look.
I'll need a roll call vote, please.
Yes.
Alderperson Carpenter?
Aye.
Essercon?
Aye.
Gantz?
Aye.
Hanson?
Aye.
Hunniger.
Aye.
Ledvina. Aye. Nelson.
Aye.
P-Rock.
Aye.
Mayor Boyd.
Aye. Motion carries. Thank you. We're going to exit to the Nicolay room, and we'll be back in just a bit.
Gantz.
Aye.
Hanson.
Aye.
Hunniger.
Conference will now be recorded.
Aye.
Nelson.
Aye.
P-Rock.
Aye.
Mayor Boyd.
Aye.
Carpenter.
Aye.
Motion carries. Thank you. We're back in regular session. I first want to thank Rachael Carriveau for showing up and presenting. I want to thank Attorney Erdman for doing what he had done, and of course, Officer Johnson and Chief Morosky for being here. I will make a motion in just a bit regarding what we're going to do, and then after the motion's done, I also will read into the record the findings of fact that has to be put in the record as well, just so you're aware what happens and the sequence of what happens. I will first make a motion to deny the nuisance abatement appeal by Rachael Carriveau.
Second.
Motion by me, seconded by Alderperson Nelson. Discussion, comments, and we had done that in closed session. That said, all those in favor say aye. Aye. Opposed? Motion carries. Thank you. In addition, the following are the findings of fact, and the appeal is properly held before the Common Council in accordance with Section 78(8)G of the DPR Municipal Code. A hearing on this matter was timely conducted in accordance with that section. On January 14th, 2026, the DPR Police Department Officer Joe Johnson issued a determination that the appellant's premise qualified as a chronic nuisance. The appellant was given chronic nuisance notice pursuant to and in accordance with Section 78(8)C and D. The basis for the chronic nuisance determination were the following activities and/or violations. A, disorderly conduct as defined by Wisconsin Statutes 947-01. B, truancy as defined in Chapter 7 and Wisconsin Statutes 125-07. 3 or more of these violations occurred within 12-month period and all qualified as nuisance activities under Section 78(8)B, specifically on October 24th, 2025, December 25th, 2025, and January 7th, 2026, and January 13th, 2026. After considering the facts and testimony presented with respect to the chronic nuisance notice and nuisance abatement before us, the Common Council has found that the determination made by the DPR Police Department Chief of Police and/or their designee was reasonable and satisfied the standards for a finding of chronic nuisance at 1380 Shearing Road, Apartment 24, DPR, Wisconsin, and its tenant, appellant Rachael Carriveau. For the foregoing reasons, the Common Council hereby affirms the chronic nuisance determination and notice thereof and denies the appeal of Rachael Carriveau. This is the final determination under Wisconsin Statutes 6812 and 6813. I'll make a motion to adopt these findings and conclusions.
Second.
Motion by me, seconded by Alderperson P-Rock. Discussion, comments? I will have one. Attorney Bungert, she does have a process after this, correct?
Right. So this is a final appealable order. So after tonight's hearing, I'll have the findings of fact and conclusions of law signed by the mayor, and then I will send that to the appellant along with information as to any further actions, and send a copy as well to city staff.
You're saying I have another chance to appeal?
There are additional appeal rights that are afforded under state statutes, and I'll not in front of this body, but in front of circuit court. And so that will be indicated in the letter, which I'll be able to email to you.
Oh, so I don't get the letter right now?
No, I'll prepare that, most likely to just have the mayor sign off on it, and I'll send that.
Yeah.
Want to make sure you knew that, okay?
Yes.
Oh, yeah, I originally did not understand the appeal process, even through the Brown County Court. And I understand that even my court order says certain things that maybe don't look good, although I do have a negative hair follicle test, which I forgot to include in there, negative for all drugs, even though I do understand that my court order says that I had a positive one. And I said I don't feel the need to defend myself against anything. However, I do think that there are issues with my neighbors, and that is absolutely what the police were referring to, and because I've smelled it
Sure.
in my house after, and I understand what has gone on now.
Okay. Yes, so all that will be sent to you.
Sure, I mean,
Any
I could
further
even
action.
pass a hair follicle test right now, probably, but I shouldn't have to. I could, though.
All right, thank you.
Thank you. All right, we have the motion to place this on file and get the procedure going then. All those in favor say aye.
Aye.
Aye. Opposed? Motion carries. Thank you. All good?
Yes, we're
Okay.
all done.
We're
Thank
all
you very
done then,
much.
Rachel, thank you for coming in.
Thank you.
Okay, let me get myself in order here because we are going to shift around here. And I'm going to move to, where am I? Where is it?
Old business.
All right, so I'm going to go to item 8, old business. Item A, consideration and possible action related to the Pere Ice Arena facility improvements and operations. To facilitate discussion, I'm going to make a motion to go with, and I'll describe why afterwards, go with stay the course +1, and I'll give you my reasoning. That's my motion.
I'll second.
Motion by me, seconded by Alderperson Levina to go stay the course +1. Now, just to back up a little bit, and Marty's available to answer as well, too. The council, so people understand, was given an overview of the ice arena at the second meeting in December. In the meantime, over the past year, myself, Kim, and then the previous city manager was involved with discussions regarding the ice arena with Marty. And then with Kim, Marty, myself, and the user groups by themselves and then collectively, we also talked about this as well too and came up with options. So I'm going to read you quickly some stuff we have prepared and then we can go from there. First, we understand that the rink is a recreational, cultural, and historical resource to the city of De Pere and the region. We recognize the value that it provides to the users of the facility. We want to preserve the rink as a community and regional amenity. But, and this is a big but, we also have to be cognizant and thoughtful about our financial capacity. The city has a number of major infrastructure projects planned for the next several years, including the Southbridge Connector that will tie up our debt capacity. The current management company and fee structure provides funding for priority improvements that have already been outlined. While we know the rink needs support, we also know that it's not the worst facility in the state. In the short term, the stay the course +1, we were presented pretty much 5 options, but stay the course +1, $2 million option, $4 million option to fix and repair. Obviously, to build the whole thing over again at $15 million. In the short term, the stay the course +1. Keep doing what we're doing. Option provides for continued repairs and layers on some additional staff support to coordinate an advertising revenue program that would provide funding for additional improvements and also increased engagement with the user groups by way of an annual meeting to explore options for continued improvement. We are open to either the $2 million or $4 million investment options. But in order to work, they must be paired with capital campaigns to raise equity in order to decrease the borrowing amount by the city. Current estimates indicate that at least $1.25 million of equity would need to be raised to make the $2 million plan feasible. The city does not have the resources to lead a capital campaign of that magnitude at this time, but is more than willing to partner with other entities that want to take this on. We will continue to contract with BCIM, Brown County Ice Management, for ice management in the short term, and they will be important partners in our conversation about the rink in the future. We truly appreciate the user group's involvement in the rink. They are critical in helping take care of the facility that we all enjoy. And please understand, we can always pivot to the $2 or $4 million option. This keeps us going as is. All right, want to put that out there? Comments, discussion. Alderperson Hanson.
So the option B, what Marty called provide the step stool, like you said, Mayor, the city, the user groups and other private parties would raise $1.25 million in fundraising. City would borrow $750,000. Have we had discussions with the user groups about how feasible they feel that the $1.25 million fundraising goal might be for them?
No, we have not gone to that level simply because what we have been trying to do is get direction from the council as far as how we want to address the rink in the future. So if the council would want to pursue the 2 million, we would then have to investigate, talk with the user groups and see if that's feasible.
But we could pivot if they come to us and say, this is something that we could potentially do.
Yeah, very similar to what the mayor had said. Yes, if user groups or even a person or business would come forward and say, we would be a supporting entity, say for the $2 million option, we can certainly pivot. Absolutely.
And then just for those who are watching, with the Stay the Course +1, do you want to just highlight a few of the top priorities that we would still try to, attack here in the short term?
Well, the number one task listed in our study was fixing the dehumidification system. So that is in the works right now. We have a contract with Bassett to do that this summer once the facility gets shut down. Then a number of different topics would be, number of different projects would be repairing of the floor, repairing of the number of HVAC units, replacing of several electric panels, and then I got to think here. There's a number of them that are up there, but the insulation on the ceiling is, while it's not the greatest to look at, it is very cosmetic. That probably is not as high, but most people see that. So those are some of the high topic things. We also have a roof issue that would need to be repaired as well.
Other questions or comments? Alderperson Carpenter.
So if we go with the approval, what you're discussing here, then you're going to have a discussion with the users after this, and then that's going to be done annually? Am I correct? So there has been no discussion with the users as of now, and then if we go with the plan, then you will have a discussion in the near future with them and really have them understand the goal. If they can go out there and get people, we are more than willing to join on.
Yeah, I'm sorry, Mayor, go ahead.
Yeah, just really quickly, we have talked about that.
Yes.
I think they're aware of that's a possibility. So I think they're fully aware of that. Okay. This just pretty much says, yeah, that's where we are, and go for it. That's what we're trying to give direction to. So to answer that question, they are aware of that we will have conversations and they with us moving forward.
The presentation we provided to council in December was provided to the user groups before we provided it to council.
Okay.
Sorry, Marty. Anything else you want to add?
No, all I was going to say is, once the council decides on a decision, we will have a follow-up with all of the user groups. Mm-hmm. So, that would be laid out with them for sure.
I really think giving them peace of mind is the fact that if we decide to go with option one, obviously the facility stays open, and I'm sure they're pretty relieved about that. And then also the fact that at any time, we can change course. If they find some cash cow out there, so be it. Let's go. And we're also looking for other revenue enhancers as well. Right. So that's on the table. At a different meeting moving forward, I would make a recommendation to continue our relationship with Brown County Ice Management and extend the terms, but that's not for this meeting right now. And that also gives us more space and time and understanding. So I'm thinking they're understanding how we're going ahead here and they're okay with this. And I don't want to speak for them. Did they want to? Did any of the user groups want to speak at all, or based on the direction you're sensing here, you're okay? You good? Okay. I don't want to speak for you. Are you all good? Okay. So we have a motion and a second. I think they understand the direction that we're going here. And again, that's for option one, keep this thing going, and then gives us more time to hopefully some money comes forward and all that kind of stuff. Any additional discussion or comments? All right, that said, we're down in the loop here. So is this a roll call vote or just a regular one? I got them all marked, but we're out of order. All right, that said, all those in favor say aye.
Aye.
Aye. Opposed? Motion carries. Thank you. Officially, we have given direction moving forward with the ice arena. Thank you for coming in and sticking around. So, okay. I'll get this cleaned up in a bit. Let's go back now to
No.
7B. All right, new business 7B. Recommendation from Finance Personnel Committee to approve Forte for merchant services using the service fee model for the beer gardens and the pools.
I'll move to approve.
Second.
Motion by Alderperson Nelson, second by Alderperson Esserkan, I believe. Discussion, comments. Alderperson Hanson.
So have we explored all options in terms of trying to find a vendor who might have a lower minimum fee for the card transactions?
Pam?
I can speak from the finance side that, no, we just went with the current vendor who we approved a year and a half, 2 years ago to use for the rest of the city. So it's the same vendor that we know works with all of our civic rec software right now. I know Marty and his staff had met, and Steve IT had met today with Forte to kind of discuss the options for what equipment could be used down at the beer garden or at the park to be able to accept these. But we did not go back out and reach this time at different companies. If we were to do that, I'd like to do that for all of our credit card machines instead of piecemealing them here and there. Well, this department uses this one, this department uses that one. That's how it was when I got here. And I tried to combine them and condense them in 24.
Okay. So we would potentially do like a request for proposals or a solicitation of bids then?
Historically, we have not for merchant service agreements.
Okay.
This was just it's the user fee that they would be paying, the convenience charge that the customer would be paying. At the time we did it 2 years ago, we did reach out to a couple different merchant service companies, and the percentage that we were getting charged from Forte was less than the current provider we had in another one, which is why we went with it. It's twofold, right? We don't want to cover the costs ourselves. It adds up very quickly, and it's an expense that it was showing in our budget. Two, we want to make sure that the customer isn't overburdened by these fees, which is why we're looking at making this change. So this change is going to reduce the current fee that they were paying last year at the pools, for instance, from a $2 minimum to a $1 minimum. So instead of your dollar candy bar being $3, it will only be $2 now with that convenience fee.
Other questions or comments? Alderperson Carpenter.
So in the packet, and I'm not opening up the packet again, but we had that scale where the prices changed, and that the reason you showed that is because you're planning on utilizing it for all.
We're using it for, we have a different, I didn't include the one from last year. We have the same tiered concept right now. The only difference is the current one is a $2 minimum, and it's a 2.8%.
Right.
So this is a higher percentage, but it has that lower minimum dollar. I mean, in order to reach the point where you're paying more than $1 at 3.1%, it's
Right.
not going to cover these little concession fees or your beer at the beer garden.
Thank you.
Alderperson Gantz.
Thanks. I would just like to tell Pam, thank you for checking into it and having the fee lowered. And also, I would like to see some comparisons down the road. So, yeah, thank you.
If I can comment, I mean, that is something that we will continue to look at with a new ERP system too, would be something that would integrate directly into our software. So this is hopefully temporary for only another couple years, and then we'll look at having something that can integrate right into our online portal, into our software, and make everything much more seamless for customers.
Nice.
Hopefully.
Other questions, comments? All right, looks like we're all good. That said, thank you, Pam, by the way. All those in favor say aye.
Aye.
Opposed? Motion carries. Thank you. 7C, recommendation from the Board of Public Works and award of contract 2504, American Boulevard Utility Extension in the amount of $1,086,000.
Make a motion to approve.
Second.
Motion by Alderperson Carpenter, seconded by Alderperson Hanson. Discussion, comments. Roll call vote, please.
Alderperson Gantz?
Aye.
Hanson?
Aye.
Coninger? Ledvina? Aye. Nelson?
Aye.
Pere?
Aye.
Mayor Boyd?
Aye.
Carpenter?
Aye.
Esserkan?
Aye.
Motion carries. Thank you. Item 7D, recommendation from the Board of Public Works and award of contract 2603, sewer lining in the amount of $339,997.
Move to approve?
Second.
Motion by Alderperson Hanson, seconded by Alderperson Ledman. Question, comments. All right, that said, all those in favor say aye.
Aye.
Opposed? Oh, I tried, everybody here. There's going to be a lot of these now. Roll call vote, please.
Alderperson Hanson.
Aye.
Conager. Ledvina.
Aye.
Nelson.
Aye.
P-Rock.
Aye.
Mayor Boyd.
Aye.
Carpenter.
Aye.
Essercon.
Aye.
Gantz.
Aye.
Motion carries, thank you. Item 7, what are we on, 7E? 7E, recommendation from the Board of Public Works and award of contract 2605, Sidewalk and Curb Repairs in the amount of $395,215.
Move to approve.
Second.
Motion by Alderperson Ledvina, seconded by Alderperson Nelson. Discussion, comments? Roll call vote, please.
Alderperson Conager.
Aye.
Ledvina.
Aye.
Nelson.
Aye.
P-Rock.
Aye.
Mayor Boyd.
Aye.
Carpenter.
Aye.
Essercon.
Aye.
Gantz.
Aye.
Hanson.
Aye.
Motion carries, thank you. Item 7F, recommendation from Board of Public Works and award of contract 2613, Crackfilling in the amount of $91,850. I'll make a motion to approve.
Second.
Motion by me, seconded by Alderperson Carpenter. Discussion, comments? Seems we're all good. Roll call vote, please.
Alderperson Ledvina.
Aye.
Nelson.
Aye.
P-Rock.
Aye.
Mayor Boyd.
Aye.
Carpenter.
Aye.
Essercon.
Aye.
Gantz.
Aye.
Hanson.
Aye.
Conager.
Motion carries, thank you. Item 7G, recommendation from the Board of Public Works and award of contract 2615, Sewer Televising in the amount of $38,958.
Move to approve.
Second.
Motion by Alderperson Hanson, seconded by Alderperson Carpenter. Discussion, comments? There is none. Roll call vote, please.
Alderperson Nelson.
Aye.
P-Rock.
Aye.
Mayor Boyd.
Aye.
Carpenter.
Aye.
Essercon.
Aye.
Gantz.
Aye.
Hanson.
Aye.
Conager. Ledvina.
Aye.
Motion carries, thank you. Item 8, recommendation from Board of Public Works to approve a declining rate structure for the water volume charges related to Public Service Commission rate case. I'll make a motion to approve.
Second.
Motion by me, seconded by Alderperson Carpenter. Discussion or comments?
I'm shocked.
I already said everything on Public Works.
All right, looks like we're all good. That said, roll call vote, please.
This one is not.
This one's not.
We're just going
My hand literally is right here. All those in favor say aye.
Aye.
Aye. Opposed? Motion carries. Thank you. Normally I do these things with my sheet. Now I do it by computer and it's all marked, but that's not the case now. It's a poor excuse. I'm sorry.
It's yours, though.
Item I. I'm going to make a recommendation rather than stating the whole thing. That we're going to receive and place this item on file. That is no longer needed, this license. So this one's done.
Okay, cool. You need a second.
I need a second.
Second.
Motion by me, seconded by Alderperson P-Rock. We will not be voting, we do vote on this, to receive and place on the file. And this would just be a voice vote. All those in favor say aye. Aye. Opposed? Motion carries. Thank you. 7J, for consideration and possible action to enter into an agreement pursuant to Wisconsin Statute 75504 with the Honorable Gregg Schreiber to act as a temporary municipal judge appointed pursuant to Wisconsin Statutes 800-061 for a salary rate of $225 per service date, subject to final review and approval by the city attorney.
Move to approve.
I'll second.
Motion by Alderperson Ledvina, seconded by Alderperson Gantz. Discussion or comments? Looks like we're all good. We need a roll call vote, please.
Alderperson P-Rock.
Aye.
Mayor Boyd.
Aye.
Carpenter.
Aye.
Essercon.
Aye.
Gantz.
Aye.
Hanson.
Aye.
Conager. Ledvina.
Aye.
Nelson.
Aye.
Motion carries. Thank you. Look what I've done. Item 8, old business. That's done. I need nothing from any of you. We're going to 9 resolutions and then eventually 10 ordinances, just so you know ahead of time. Resolutions can be taken up with one roll call vote with a suspension of the rules. The same goes for ordinances, unless any alders would want to discuss any item separately. We're just throwing that out there. So take a little peek at it. I'll give you a second.
And even if you pull one out.
Let me look at.
Even if we pull one out, we can suspend the rules for the other ones.
Correct.
Alderperson Hanson.
I would like to request pulling out 9F and 9H.
And that is on 9F and 9H resolutions.
Yes.
Anyone else have anything?
I'm looking.
All right, Alderperson Carpenter.
Where was the Yes, I'd like G pulled, please.
Should I just go through them?
The Archer Company.
We can still do A through E.
Okay. All right. Anyone else have something they want pulled? We'll just stick with resolutions right now. That want pulled from resolutions. So then I will suspend I'll make a motion to suspend the rules for items 9A through
9E.
9E.
A second.
Motion by me, seconded by Alderperson Nelson to suspend the rules and vote for these all as one. It's chaos.
Yes, suspend the rules, so then voice vote.
Okay. Everyone good with that? Okay. We have a motion and a second. All those in favor say aye. Aye. Opposed? Motion carries. Thank you. I'm now going to 9F. All right, 9F.
You have to
No, wait.
motion to approve.
You have to do a motion to approve those items, A through E.
And that'll be a roll call.
I'll make a motion to approve items A through E.
Second.
Motion by me, seconded by Alderperson Levina to approve items A through E. And we don't have really any discussions or comments on this, right? Because it's technically a consent agenda. They already pulled out what they want.
Correct.
Okay. So that said, we will now need a roll call vote.
Correct.
Thanks for the help out there. by the way.
This is faster.
Mayor Boyd,
Yeah, right.
Carpenter,
Aye.
Estercon,
Aye.
Gantz,
Aye.
Hanson,
Aye.
Conager, Ledvina, Nelson,
Aye.
P-Rock.
Aye.
Motion carries. Thank you. I have this now. If the meeting was tomorrow, I could figure this out. Now I'm going to where? Right.
9F.
Item 9F, Resolution 2611, rescinding property taxes and approval to pay net taxes utilizing unassigned reserves for parcel numbers ED6 and WD4781.
I'll move to approve.
Motion by Alderperson Nelson, seconded by Alderperson Ledvina. Discussion or comments? Alderperson Hanson.
Yeah, Pam, I just wonder if you can give a little more context of what led to this error. I mean, it sounds like it was expected that they only had to file the exemption once every 2 years, but it's actually annual. So I'm just wondering what processes we might put in place to make sure it doesn't happen again.
I'm going to actually let Carrie.
I can address that.
Okay.
So every other year, and even numbered years, the tax exempt property owners have to file something with the clerk for reporting purposes. Then annually, certain types of tax exempt properties have to report to the assessor. And I received something last spring from this particular property. I misunderstood, thought that they were doing something they didn't need to do because it wasn't the correct year. So I neglected to forward that to Accurate Appraisal.
Okay.
Because I didn't understand that there was a whole separate reporting process happening annually between NeighborWorks and the assessor. I thought they were just doing something in duplicate.
And this covers all the NeighborWorks parcels in the city then?
Yes.
Thank you.
All good? Good question. Alderperson Carpenter.
Just so everybody understands, it's going to come in out where the money is coming from, but we are recouping our money, not the whole 5,000 or whatever the number was in the budget. I'm not opening the packet all together again,
No,
but
we will recoup the money that was dispersed to the other taxing.
yes, I mean, eventually, so it is not as big of a loss
Right.
as it was, just so everybody understands.
Very good point. Thank you.
Yes.
Other questions or comments? All right. We need a roll call vote, right?
Yes, we do.
Roll call vote, please.
Alderperson Carpenter.
Aye.
Estercon.
Aye.
Gantz.
Aye.
Hanson.
Aye.
Conager. Ledvina.
Aye.
Nelson.
Aye.
P-Rock.
Aye.
Mayor Boyd.
Aye. Motion carries. Thank you. Up next, 9G. Resolution 2612, authorizing agreement for professional services with the Archer Company LLC, classification and compensation study. I'll make a motion to approve.
Second.
Motion by me, seconded by Alderperson Nelson. Discussion, comments? Alderperson Carpenter.
I realized there was like 6 companies that gave a proposal price to this. Can you tell me where this company fell in line?
Yes.
See, we're going to give that to you.
All right, perfect. So as you had saw that there were 12 companies that we had put this proposal out to, we received 6 companies that were received 6 responses. Kim, Shannon, and myself had reviewed those, and we came down with the top 3, which were interviewed by ourselves as well as additional city staff. And within there, this company, I can't remember the exact cost of the other ones. I know that there was one that was lower. I think it was about 20,000, and I can't remember what the cost of the other one was. And this one did end up coming in at that 34,390, which is within what we had budgeted for this project.
I understand it falls in the budget, so my next question is, so it wasn't the lowest one, this happened on the last time it was done, and then in the packet it said it was reviewed by multiple staff people. Who was all in the staff? Can I have that information?
Yeah, absolutely. It was myself, HR Director Metzler, City Manager Flom, and then there was Jake Nowak, our police captain. There was Brian Krisnovich, which I know I probably said his last name wrong, our park superintendent. And then we also had Daryl Carter from Public Works and Craig Pearson from our finance department.
And the reason I bring this up, because I feel like that's like the fox guarding the chicken house. I hate to say it in that way, but this is a benefit for it's going out for scale. It's for our employees. I think council should, or some, I don't want to micromanage the process, but I do think council should be involved in this to make sure, because we're all human beings and we pick out who we like, and there might be something understating. And not to be saying this is what's happening, but I just think besides management, there should be others involved.
Thank you.
That's my only comment.
No, thank you, and noted. Appreciate that.
I have some of the pricing on the other ones,
Oh,
Tracy,
perfect.
for my
Thank you.
spreadsheet, if that would be helpful. So we had one that, and one of the things to note is when they did provide the proposals, some split them into like different options of proposals. So one came in around 45,000. One came in around 35,000, one 21,000, one 5,000. One was somewhere between 22,000 and 28,000, and then the Archer Company at this following one. I can say, hopefully I can say that it was a unanimous. We had a very big panel and a panel that represented individuals from many different departments and different places in the organization, be it a frontline employee all the way up to me as the city manager. And it was a very easy, unanimous decision on the consultant that was selected.
And I'm not disagreeing. It's just, I just feel you're picking your own wages.
I can understand that perspective as well, yes.
I just want to bring that perspective out.
Thank you.
One thing I will add, and Tracy, you can probably compound on this, actually one of the reasons we really liked the Archer Company is because they had the most robust methodology that was actually very, very data-based. And they had a methodology that has been used across the country and has been in place for years. And we think that'll be very beneficial for us, knowing that the world of compensation can have a lot of emotion attached to it.
Yeah, and I did go through a lot of this, and yes, they were very detailed and very, as I went through this packet. Don't get me wrong, I just thinking maybe some could have one or two people else in it.
All right, thank you. Other questions or comments? All right, roll call vote, please.
Alderperson Estercon?
Aye.
Gantz?
Aye.
Hanson?
Aye.
Conager? Ledvina?
Aye.
Nelson?
Aye.
P-Rock?
Aye.
Mayor Boyd?
Aye.
Carpenter?
Aye.
Motion carries. Thank you. Tracy, thank you. Thank you for sticking around. Up next, 9H, Resolution 2613, authorizing agreement for contractor services for Dark Horse Deconstruction LLC, demolition 126 South Broadway Street. I'll make a motion to approve.
Second.
Motion by me, seconded by Alderperson Carpenter. Discussion or comments? Alderperson Hanson.
So we have the connected property next to it, 132 South Broadway, the old Century Lanes. Staff mentioned that initially we were going to raise them both at the same time, but the property owner at 132 decided to do theirs independently. I'm just wondering if staff can share any information publicly about why the private property owner at 132 decided to go separately and what their timeline is for taking down that building.
Well, Dan, you want to go with that?
Sure.
I'm assuming so, yes.
Yeah, the private property owner has just elected to do the demolition on their own, and as such, it's their right to do so.
Do they have a timeline that they've shared with us?
At this point, it would be up to their contractor.
And then in terms of the request for proposals, so this is one's a little different. We don't have to just do the low bidder. There's 5 criteria. Each are weighted 20%. 2 of the 5 essentially get to qualifications and experience. The low bidder that we're recommending, they only listed 3 projects, all in Milwaukee, 2021, 22, and 24. Some of the other bidders had much more extensive projects that they listed, including some that were in this area. Did the low bidder provide any other additional information about projects that they've done, let's say, over the last 5 years, and if any of them are in this area?
What you have in the packet is what was submitted as a response to the RFP. And so we didn't include anything. We didn't request any more information. The review team evaluated each proposal based off of what was submitted. You did see that one of those submissions was actually disqualified for incomplete application. But in general, as you may have seen in the letter or in the memo, it was all very close in what we felt were qualifications and experience. Whether or not that was in this part of the state or a different part of the state, the rules are the rules. And so as a result, staff felt that that was appropriate.
Doesn't sound like you're done. Are you done? I thought you're...
Well, I was just wondering kind of exactly how staff applies the criteria in terms of those 2 categories of experience and qualifications.
So I assume you're referring to project approach and scope and qualifications of project team? Those 2 are, is that the 2 that you're referring to, or understanding required project work? Which one of the?
Yeah, let me pull it up again.
It would be probably number 2, the experience of demonstrated ability of the project.
Yep,
manager.
qualifications of project team and individual members, and then 3, project team experience and examples.
Mm-hmm. Yeah, both after the RFP responses were looked at, we also, as you did see in the reference to these recommended team, that there was also reference to a name of a former company or a quasi-relation of a company. We also did evaluate that company as well, just based off of, again, the project work and the people doing the work. And that's often happens within an RFP process where you have somebody who's done work in their past from another organization that is referenced in that RFP. That's not unheard of. We seal it all the time in quite a few RFPs. So we do evaluate, past experience. And so that's, again, part of one of the recommendations that came, or the reason why one of the recommendations came the way it was.
And did we cross-check with the references provided?
And these ones our staff members did do cross-reference checks on 2 of the, I guess you'd say, the top ones, yes.
Okay. I'm good now.
Thank you. Other questions or comments? All right. That said, we'll need a roll call vote, please.
Alderperson Gantz?
Aye.
Hanson?
Aye.
Conager?
Aye.
Ledvina?
Aye.
Nelson?
Aye.
Pirog?
Aye.
Mayor Boyd?
Aye.
Carpenter?
Aye.
Estercon?
Aye.
Motion carries. Thank you. Again, for ordinances, the same thing applies if you want to suspend the rules and/or pull something out. Does anyone want something pulled out of what's in the ordinances?
No.
Since I didn't do well the last time regarding what I was supposed to say, I will make a motion to suspend the rules. Did I do that okay?
Yeah.
All right.
Second.
Motion by me, seconded by Alderperson Ledman to suspend the rules regarding ordinances. To take it up with one roll call vote. All right. That said, we have a motion, a second. All those in favor say aye.
Aye.
Aye. Opposed? Motion carries. Thank you. Then I'll make a motion to approve item 10, A, B, C, and D.
I'll second.
Motion by me, second by Alderperson Ledman. All good? And then we need a roll call vote, please.
Alderperson Hanson?
Aye.
Conager?
Aye.
Ledvina?
Aye.
Nelson?
Aye.
Pirog?
Aye.
Mayor Boyd?
Aye.
Carpenter?
Aye.
Estercon?
Aye.
Gantz?
Aye.
Motion carries. Thank you. I am so proud of myself.
This is so fast. Proud of you too.
Thanks to the help from everybody here. Item 11, future agenda items. Does anyone have anything? Alderperson Hanson.
Yeah, so the county was supposed to present tonight on the aesthetic features of the Southern Bridge. I understand that's being delayed to March. I'm wondering if we can also get an update from them on the status of the name of the future bridge, because it's been about over a year since the council passed a resolution expressing support for the name Arthur Altmeyer, after the De Pere native who was the architect of Social Security program. So I'm just wondering where that's at.
Very good, thank you. Good, that'll be sent forward. Other future agenda items? Won't be that. All right, moving on. I'll make a motion to adjourn.
Second.
Motion by me, seconded by Alderperson Nelson. All those in favor say aye.
Aye.
Opposed? Motion carries. Thank you. We're officially adjourned. Thank you, everybody.